Hello, and welcome to the Educator License Discipline Overview presented by the Educator License Discipline Team of the State Board of Education. The State Board of Education consists of 10 voting members representing the 9 congressional districts and including 1 student member. The board is a nonpartisan body appointed by both the governor and the legislature. The board staff supports the work of the board and is led by Executive Director Dr. Sarah Morrison. The board staff includes a 7-person legal team, the majority of whom focus on educator license discipline matters. Here we have the current leadership and legal staff. The 3 associate attorneys and 2 paralegals handle cases based on assigned districts so that stakeholders are able to build a relationship and have a consistent point of contact with the same attorney and paralegal. The state board has a duty and power to adopt rules and policies governing the discipline of licensed personnel for misconduct by formal reprimand or by the suspension and revocation of licenses and certificates. Additionally, the board has complete jurisdiction over the issuance and administration of licenses as outlined in Tennessee Code Annotated 495101 and the sections following. The board, acting in accordance with the statutory mandate, promulgated Rule 0520-02-03-.09, which outlines reasons why applicants, teachers, and administrators may have applications denied, license formally reprimanded, suspended, or revoked, or permits not reissued. It is important that educators know and understand that every educator who is licensed by the state of Tennessee is subject to the license discipline rules promulgated by the board no matter where they teach within the state. It is important that educators know and understand that every educator who is licensed by the state of Tennessee is subject to the license discipline rules promulgated by the board no matter where they teach within the state. Equally important, every director who employs a licensed educator, whether in a traditional public charter, or non-public school, is required to report incidents or behavior that would be subject to discipline as outlined in the board rules. Failure to report by a director who is a licensed educator could result in a formal reprimand or suspension of their license. If a director who is not licensed fails to report, they could be subject to a public reprimand. It is recommended that charter schools or associations and non-public schools have a clear understanding of who is responsible within their organization for reporting. The license discipline process can feel long at times. It's because there are many steps between a report being made and the eventual conclusion of the case. Let's take some time to walk through 4 major steps with particular emphasis on the first and second. When reports are made, they are placed in the educator license discipline queue for review by the attorneys and paralegals. Cases are opened and placed under review once a month at the beginning of the month following the report. For example, a case reported on March 12th will be open for review by the educator license discipline team on or about April 1st. You'll notice 2 green check marks on this slide. These checks represent points at which cases are cleared without further action. When a report is received, it is placed under review only if a board discipline rule is implicated. Additionally, if a duplicate report is created, the duplicate report will be cleared while the original report will remain open. Another instance in which a report is cleared occurs when an educator was previously placed under review and the matter was resolved. That person would not be subject to review again for the same incident. Reports come from 5 sources: directors or local education agencies, the National Association of State Directors of Teacher Education, or NASDAQ, which is a national clearinghouse, personal affirmations created by educators applying for licenses or permits, the Department of Human Services as it relates to delinquent child support, or they can be created by board staff based on information received from credible media reports or other sources such as a parent. Directors or their designees are able to make their reports in TN-COMPASS. You will find the forms you need to make a report on the SBE website at tn.gov/SBE. Additionally, on our website, there are how-to videos demonstrating how to start a report or update a report. A question we often receive is, when should we make a report? State Board Rule 0520-02-03-.09 outlines that whenever an educator is suspended, dismissed, non-renewed, retired, resigns, or is demoted following or due to allegations of misconduct that would warrant licensure action such as a reprimand, suspension, or revocation, that the director shall report within 30 days of the incident or becoming aware of the incident. An example, a teacher comes to school with alcohol in their backpack in the classroom on March 1st. However, the administration does not find out until April 15th. Once the administration finds out, then the director or their designee shall report within 30 days of April 15th. It is important to note that if an internal investigation is concluded within 30 days of the incident and there is not a basis for the allegations, then the director need not report it. For example, a teacher is alleged to have used a curse word towards a student in a text message on March 1st. The school investigates and reviews the text between the student and teacher and finds that the allegations are untrue on March 26th. There is no need for the incident to be reported in TN-COMPASS. However, if that investigation continued through April, then there would need to be a report made in TN-COMPASS. It's important to note that reports are made only for incidents or behaviors that are subject to discipline. As you can see on this slide, and based on our rule, we discipline both explicit and non-explicit inappropriate communication and inappropriate physical contact, criminal offenses and convictions that are felonies or involve a child, test security breaches, being under the influence of, consuming, or possessing drugs or alcohol, negligence, and issues that fall under other good cause as outlined in the Teacher Code of Ethics. The key to remember is that student safety is at the center of the rule and discipline decisions. We generally do not discipline personnel matters. For example, an educator is perpetually late to school but has no instructional or supervisory responsibilities for first period. This is a personnel matter. However, if the educator was perpetually late to school, leaving their first period class unsupervised daily, then they may be subject to discipline. Note the green check, as these types of cases are generally cleared without being placed under review. Once it is determined that allegations contained within a report or personal affirmation could violate SBE discipline rules, the report is placed under review. The State Board of Education is not an investigative body. As such, we rely on schools, school systems, educators, law enforcement, and other entities to provide information related to a reported incident. Our rule in section 0.09 subsection 2 provides that schools are required to respond to board inquiries and provide all information unless otherwise prohibited by law. Though SBE is not an investigative body, we do have subpoena power to compel the production of evidence. Please remember that individuals who are placed under review still hold a license, and a review does not prevent an individual from being employed in and of itself. Schools and school systems should preserve all evidence related to a report. Here we have a familiar acronym repurposed to help with evidence collection. First, preserve all evidence, all videos, texts, electronic records, or anything else that could be deemed relevant. Second, eyewitnesses and potential witnesses should be identified, including students, teachers, personnel, or anyone who may have knowledge of the alleged incident or behavior. Next, maintain all records kept in the regular course of business, including letters to the educator, emails, or other forms. D, distill the information to writing. Original statements from witnesses and the educators are more useful than summaries provided by administration. A, act quickly to preserve information and evidence. Retention rules and policies within your district may cause evidence to be deleted. And finally, send us all of the information as required by the rule. After all information is gathered, the case is presented by the legal team to the Case Review Committee. By rule, the Case Review Committee need only be composed of the Executive Director, General Counsel, and at least one staff member. However, we have additional staff on our Case Review Committee so that there are a diversity of perspectives, including those of former classroom teachers and people with varied life experience. The Case Review Committee hears approximately 20 to 30 cases each month, with a focus on consistency, efficiency, and student safety as our guide. Finally, if the Case Review Committee recommends discipline, then the educator is sent a Notice of Proposed Action, or NPA. The educator can do one of three things with their NPA. They can either sign the included consent order and indicate their agreement with the recommended discipline. They can request a contested case hearing, or they can do nothing, which will lead to a default hearing before an administrative law judge. Here are your key takeaways. Every educator licensed by the state of Tennessee is subject to these rules. Directors are required to report incidents or behavior within 30 days of the incident or becoming aware of it. And finally, additional resources can be found on our website at www.tn.gov/sbe/licensure.html. Thank you for your time. Please sign up for our newsletter by scanning the QR code pictured here on the screen. And if you have additional questions, we can be contacted by phone or email as indicated on the screen.